today I thought, because everyone is talking about what's happening in Parliament, we would get some definitive views on the position of the Constitution, on whether or not the Mike Oquaye ruling should be applied in the case of these most recent 4 members of Parliament who have expressed, or in fact set about their intention of becoming independent candidates in the next election. And who better to help us with that than Professor Kofi Abuchi, Dean of the UPSA Law School. Prof, good morning to you.
Good morning, Kojo. How are you?
I'm very well, thank you. Now, Professor Mike Oquaye, whose ruling, is being held up as the precedent in this argument, himself says that, well, the circumstances are different. In his case, the matter was brought up by the political parties, which is what led to the ruling he gave, and that is what he expects to happen in order for this situation to be the same as his situation. Do you agree?
I think in order to understand things better, we have to move beyond different factual circumstances. Otherwise, we would have to be evaluating things every time from case to case. And I think that's a bit confusing. So perhaps we should look at things from a more principled standpoint. And the big question we ask ourselves is, whose agent is the MP? Is an MP the agent of the Constitution? Is he an agent of the party? Or does he represent himself? I would argue that the MP is mainly an agent of the Constitution, and then secondarily, he is an agent of the party. And the reason I argue is because the MP, when in Parliament, he is not recognized ordinarily as a member of a party. He is recognized as a member of Parliament. And that is why Parliament as a body is a body. The parties are only a vehicle to enter Parliament. Now, if you go to elementary principles, the Constitution says whatever is in violation of the Constitution is void. That means if anybody acts in a manner which is considered unconstitutional, regardless of the activation of a process by a party, by a citizen of Ghana, by other members of Parliament, regardless of anybody taking any step, the action is intrinsically void. So therefore, if a person sits in Parliament unqualified, and in this case, if the person, for example, crossed carpets, and by reason of that, the person is supposed to lose his membership of Parliament, if that person continues to sit in Parliament, whether or not a party reports, whether or not a party takes steps, and therefore the speaker acts in a manner that ultimately results in the expulsion of the person, whether or not any such thing happens, the person would have been sitting in Parliament unconstitutionally, which means the person would have been sitting in Parliament unqualified, which also then means the person would have committed a constitutional crime as it is spelled out in the Constitution. That therefore undermines the argument that a party should be the one ordinarily to report, or even a member of Parliament, or whether or not we should even do anything at all about this before something happens. It undermines that argument because the person would have fundamentally violated the Constitution, or the constitutional requirements that you should sit in Parliament only when qualified. Which then leads to the other question. If a person sits in Parliament unelected, or rather unconstitutionally, so to speak, the person's actions by way of voting and other consequential remedies, which includes his representation of the people he's supposed to have been elected into Parliament for, that representation will have been nullified. That has a huge consequence and repercussion. And that is what fundamentally undermines the argument that the obligation to correct that, or the obligation to ensure that that doesn't happen, is exclusively reposed in a party. It undermines that argument. Because what that means is, if a party doesn't take steps to do that, it means we are condoning the unconstitutionality. It means we are accepting what is otherwise wrongful. And it means that the people for whom that particular MP is supposed to be in Parliament or representing, those people would have been without a representative. The whole repercussion is so huge that one party cannot have an exclusive right to mediate the process. And that is why, in my opinion, everybody actually technically has a right to report this. In fact, members of parliament can do that. The parties can do that. Non-members of parliament, ordinary Ghanaian citizens, can petition the Speaker of Parliament to ensure that such an anomaly is rectified if ever a thing like that happens. So I do not think that ordinarily this is exclusively vested in the party, for which cause in the absence of the party's report, anything can't happen. I need to hasten to add that the structure or the framing of the provision itself in the Constitution, Article 97, doesn't even mention reporting, so to speak. The Constitution says that the person shall primarily take the step himself. A person becomes disqualified if he crosses carpets. So ordinarily, even the reporting part is a secondary thing. If the person doesn't himself take steps to report himself to the Speaker, or just stop being a representative, then we have the secondary step of that person being reported. And I can understand the argument the Speaker was making, the former Speaker was making, that because he's a member of the party, ordinarily the party will report. But we should also not forget the fact that parties may have an incentive not to report a thing like this, and which would lead to all the things that I've said earlier, whether we are condoning unconstitutionality with all the consequences that follow if we follow the exclusivity argument.
Right. Okay. If you just joined us, we're talking to Professor of UPSA's Law School, and we're talking about the constitutional implications of what's happening in Parliament, with 4 members who intend to be independent of their political parties in the next election.
Great. So, Professor Abochi, let's just look at something. You've talked about, what the Constitution says, just by way of clarification. When you talk about the fact that once a person crosses carpet, could you help us understand what crossing of carpet means in Parliament under the circumstance? And then I'll follow up with my next question.
First of all, again, it's important to understand why the Constitution has a provision like that. I always want to go to the policy rationale of things, because that's the only reason we understand these things. Now, a person is elected into Parliament on a certain promise. In terms of standing on the ticket of a particular political party, the promise is that he's saying, I associate with this political party. I believe in their ideology. I believe in their programs. I believe in their vision. Elect me, and by your electing me, I am going to advance the policy vision, the philosophy and the ideology, etc., of that particular political party. So the assumption is that, among other considerations, the electors chose you partly because of your association with the party, or if you're an independent candidate, with your non-association with the party. Now, having been elected, and you being in Parliament, suddenly you repented. You changed your mind for whatever reason. You wanted to associate yourself with another political party, or as in this case, associate with no one. The Constitution is saying that because your earlier promise, on the basis of which you were elected, has changed, you will have to vacate your seat in Parliament. If you want to return to Parliament, go back to the people, tell them this time that you are no more part of the party, or you are now part of a certain party, and see if they will re-elect you. So it makes some sense.
Okay.
And crossing carpet in this sense means that you essentially would have moved from one aisle to another aisle, or you would have moved from one aisle to a no aisle. Whichever way, you are no more the member of Parliament you used to be by reason of your identity. Okay. So the crossing carpet situation is an identity politics, which the Constitution recognizes.
Great. Now, the composition of Parliament itself allows 2 sides, minority and majority. Now, the position of the Constitution you talk about also, we have been told, stems from happenings in the 1960s where people crossed carpet, moved from one side of the house to another. Here we have a situation where an independent member of Parliament is doing business with the majority side, decides to contest on the ticket of the majority party that he does business with. You have an NDC member of Parliament who says, I want to contest as an independent candidate. However, he has not said that he is going to change position in this parliament. How does that amount to crossing carpet when he is still in parliament and his decision is only becomes useful in the next parliament?
The difficulty with the current motion, and motion in quotes, I don't know if they formally tabled the motion in this respect, but the difficulty with the position seeking to expel these MPs lies in one important fact, and that important fact is that the Constitution, among others, uses the word seeks. That is where a person seeks to, say, change his party or become an independent candidate. Now, seeking to do something implies a number of things. First of all, it's a mental dynamic. So it's something that someone should have come to a certain cognitive conclusion, a decision that he's making a particular move. So we have to have come to a firm conclusion that judgment has been formed, which requires some investigation. It requires perhaps some hearing. So those making an argument that the person should be heard or the people should be heard, it's a legitimate argument. It's a legitimate argument because we'll have to investigate whether or not they are actually seeking to lead the parties for which they are members. So it's not just a declaration that I'm going to contest on the ticket of the party, but it is a decision to want to lead the party in the current circumstances of things. And that requires an investigation. So you can't just peremptorily come to a decision or conclusion that because a person is going to contest on the ticket of a party, he seeks to lead the party. I think there's more complication in the provision, perhaps, than we've been treating it.
Okay.
And I think part of the reason for that is to ensure that we do not also throw the baby out with the bathwater, I'd say. We don't, in the process of trying to rectify one problem, also undermine a number of things in the Constitution. Because, mind you, a member of parliament is not representing himself. And if he's kicked out unlawfully, among the consequences, as I've indicated earlier, you are depriving a whole group of people representation in parliament. It's a decision that is not to be taken lightly, and therefore, while there must be consequences for constitutional breaches, those consequences must be arrived at not lightly, just so that we ensure that ultimately, as I indicated, we do not compromise not only the Constitution itself, but also the very people that a member of parliament represents as an MP.
Now, Prof, because for many of you, because of your language normally, let's bring it down. So, in the case of the second Deputy Speaker of Parliament, who is an independent member of Parliament for the people of Fomena, currently doing business with the NPP as a majority, beg your pardon, if he decides to come to Parliament, and he's decided to come back to Parliament in the next Parliament, the 9th Parliament, this time around on a ticket of the NPP, has he, in doing so, crossed carpet?
I would not want to make a definitive judgment on that, except to say, again, back to the law. The law says if he seeks. So if an independent member of parliament decides to join the party officially in parliament, he would have to vacate his position and seek re-election. The difficulty with this is that there must be a clear judgment and a statement of that while I'm in parliament, I am seeking to move from one aisle to the other. I think your own use of language indicates that they have deliberately or tacitly avoided that difficulty.
Great.
By not declaring that they are shifting from one party to the other, but that they are doing business with the party. So in essence, he was in parliament. He was not a part of the party in that sense, but he was doing business. He was associating himself in terms of thinking, so to speak, with the party. But if he decides that he was going to join the party officially, and the reason he didn't have to do that is because he was already part of the party. So that's the difficulty for him. And in fact, it's interesting that the issue wasn't even raised. The issue should have been raised much earlier, whether he was still a member of the party. Because if he was a member of the party, then he would have not only sought to join the party, but he would have actually been part of the party. The Constitution's provision gets activated when you have shifted membership. It is not just identity with the party. So in the case of the second deputy speaker, many people will tell you that perhaps the NDC should have actually fought that many weeks, months ago, when the issue of his membership of the party perhaps was never changed. At the time, he shifted to independence. He remained an independent candidate, yet in reality, everybody knows he's still a member of the party and he was still doing business with the party. So that is what the problem was. So it's not just a declaration that I'm going to contest on the ticket of a party at the next election. It is a declaration of you shifting your membership of the party while you are in parliament. Because what the Constitution doesn't accept is the fact that you entered parliament with one language. And while there, you decided to change the language on the basis of which you acted. The Constitution says you can do that. But if you declare an intention for the future parliament, that's a different declaration. And I think that that is more nuanced and perhaps should be looked at a bit more carefully. And that's why the former speaker's position, it's not exactly something I would subscribe to. And the reason for that, as I've already argued, is that the parties are not dominant or in charge of the process. Parliament is in charge of the process. And all of us can petition Parliament for that purpose.
So if I get you clearly, you're saying that the issue is more nuanced once the person is not shifting, moving from one aisle to the other, but indicates, while maintaining his current position in Parliament, as in where he is, that in the next Parliament, he wants to come to Parliament as either an independent candidate or belonging to another political party.
Correct. The Constitution's consideration is about the ongoing Parliament. A declaration of intention for the future Parliament is a declaration for the future Parliament. So I can say that I'm going to repent my political position in December. I'm going to stand on a certain party's ticket. That is a declaration for the next Parliament. The Constitution is concerned about your declaration for the current Parliament. If therefore your declaration is one that shifts your position from a particular party to another political party, from independent to a political party or a party to an independent, that shift of position for business in the current house, that is what the Constitution is about. Your declaration or shifting of positions for the future house is something for the future.
So once it doesn't affect your position and the way you do business in this current house, in this 8th Parliament, you can continue with your business.
That is the conclusion I would come to. But as I indicated for the second deputy speaker, it's rather surprising that the issue wasn't tackled, because he has at all material times remained a member of the party. And it's a fact which is known. I'm not aware whether he resigned. But if he remained a member of the party at all material times, then it means he really was never independent.
He was actually dismissed from the party.
Okay.
Yeah. Okay.
Right, Prof. Kofi Abochie, I want to say a big thank you to you for joining us with very interesting insights on this matter. We appreciate your time.
Thank you.
Yeah, well, there we go.
Interesting explanations there from the legal luminary, if I can use that expression from him. But for me, for the street man that I want to play in, I mean, the intention to act as an independent candidate is for the next Parliament. As we speak right now, these persons have not crossed carpet for that action to take effect. And so, well, a futuristic plan. How does the law play into that?
I still have questions. Is it a futuristic plan if they have filed to run as independent candidates
in the next Parliament, and not the current
but
Parliament?
They've done so while they are members of a particular party. They have declared that going forward they will not be members of that party. Does that activate a process or not? Right? And I mean, Prof. Abochie agrees with Winston that it doesn't, because it's a future thing. So they are saying what you are saying. I'm just wondering whether there are no legal consequences to taking an action, right? If you go and file a legal document saying that I will be independent of my party,
when this current session is over, in this current session, I am still with this side A or side B. I think it's clear. I don't think there's any ambiguity about this thing.
People always talk about the spirit of the law.
In the letter of the law.
The spirit of the law. And, the general idea behind even the law. They will tell you why they're doing these things. And so we've talked about the hybrid system. We've talked about how in the Third Republic, a budget was rejected. And because we rejected a budget, we believed that in having members of parliament serving as ministers, it would prevent that from happening. I didn't think that made a lot of sense, but anyway, that's what we have said, and that's what we are practicing. The whole idea of this crossing of carpet is what happened in the 60s, where people could just move from one side to the other. And look, many people have forgotten what brought Alhaji Inusa Fuseni to parliament the first time. Now, Professor Wayuseni, who at a point in time was the vice chairman of the NPP, following the murder of Yakubu Andani, decided to leave the NPP and join the NDC. At the time, Inusa Fuseni was in line. He had wanted to contest as the NDC's parliamentary candidate for Tamale Central. Okay? At the time that he had lost in 2004, it had been made Tamale Central. In the past, it wasn't Tamale Central, but it had made Tamale Central. While he wanted to contest that seat, they convinced him to let the Professor Wayuseni contest. Professor Wayuseni contests, wins the seat, comes to parliament on the ticket of the NDC. Then in 2006, he announces that he doesn't want to be a member of the NDC again. He's going to the NPP, which is his party, and said so I am crossing to the next side. But you cannot cross to the next side. So the Constitution said you couldn't cross to the next side.
Let me ask you this though.
But let me land anyone. While he attempted crossing, you cannot cross. So they decided to have what? How do you call it? They decided to have a by-election. And Professor Wayuseni decided to contest as an independent candidate, and he lost to Inusa Fuseni. Yes, ask your question.
So in parliament, you said it yourself, there are two sides, right?
Yes.
There's the majority and the minority. It's not the MPP and the NDC. It's not party A and party B. There could be 5 parties in parliament. There could be independents in parliament as well. But there will always be the majority and the minority, right? So when you say crossing carpet, are you referring to crossing from the majority to the minority?
Exactly.
Are you referring to crossing from one party to another? Are you referring to crossing from one party to becoming an independent? What constitutes crossing carpet?
Moving from one side to the other. But
majority to minority. But not moving from one party to another. So if there are 2 parties in the minority.
Hold on a second, so I would explain. The Constitution and the Parliamentary Standing Orders talks about a majority party or group. And Urban Bagman is interpreted as a group. So where you don't have, no party forms an obvious majority, parties can come together. Now, if you decide, and so you are sworn in as belonging to this group, if you decide in the same parliament that you want to move to another group,
the minority,
you don't have any business being.
But what if you want to move from one majority party to another majority party? The 2 parties are in the majority.
You have not crossed carpet.
Interesting.
It is the reason.
So you can change parties, but as long as you don't change sides, you haven't crossed carpet.
You haven't crossed carpet.
That's interesting. That's an interesting interpretation. But our time is up. First, let's apologize. We weren't able to bring you the BBC News today for good reason. We were having a very important, educative conversation with Professor Abuchi.